All right, good afternoon, everyone. Welcome to another live question and answer session. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin, and I work out of the Ottawa office. So I'm here today, as I am about every couple of weeks, to answer all of your questions. So if there are any questions that you have, now is the time to send them in. Questions about severance pay, terminations, layoffs, workplace and safety issues, health issues in the workplace, COVID layoffs, anything related to COVID-19. Unfortunately, now that we're in another provincial lockdown in Ontario, at least. So I'm going to be here for the next half an hour, happy to answer any and all of your questions as they relate to employment and the workplace. As always, if you don't have a chance to get your question in, or if we don't get a chance to answer your question today, please reach out offline. You can always email myself, or you can email the firm directly by going to employmentlawyer.ca, and you can reach any of us that way. All of my contact information is there. All of the lawyers at our firm have their contact information there, and you can contact any one of us directly if you do have a question that didn't get answered today. So again, I'm here for 30 minutes. Send in your questions. Don't be shy. As usual, I do have a few things that I'm prepared to talk about today that I wanted to highlight for everyone that's watching. But I would much prefer answer your questions. It's a little bit more interesting. So don't be shy. Send in your questions, and we'll get started. So while I'm waiting for some of you to send your questions in, the first thing that I wanted to talk about, which has been in the news this week, and I think, last week a little bit with respect to the lockdown and some of the schools closing in Ontario, at least, is that, lots of parents are calling us with concerns about what they should do if their child's school has been closed for the next couple of weeks, or maybe longer. We'll see what happens. And they can't find childcare. So this is really important to keep in mind. If you're a parent, if you know somebody who is either a parent or a guardian of a child where your school is closed, then you can have your employer accommodate you to work from home. So if, let's say, you work from the office, you're not already working from home, you're not already working remotely, and unfortunately you have no options for childcare, your child's school is closed, you have to have them home, that means you have to be home to care for your children, then you can ask your employer for an accommodation to work from home. And the employer does have to allow you and accommodate you to the point of undue hardship. So there's a couple qualifiers that are important to keep in mind. It's not a blanket obligation. So the first thing is, if you're a parent dealing with this issue and you want to request to work from home to look after your children because their schools are closed, you have to exhaust all other options first. So if you do have other childcare options available to you, then you should be using those and utilizing those options. So if somebody can watch your child for you, if there's a daycare that you can have your child in, if a family member can take care of your child while you're working, all of those are perfectly fine options. You have to exhaust all of those options before you ask your employer for that accommodation, in the sense that they only have the obligation to accommodate you once you've exhausted those options. Some employers may be a little bit easier to deal with, where even if you don't exhaust those options, they may simply accommodate you and allow you to do that. It's just a pretty reasonable request. But from a legal perspective, they only would have to accommodate you, and they'd have the legal obligation to do so if you have no other options and you've exhausted other options already. The second qualifier is, if you've exhausted all options and you want to request that you be accommodated for childcare obligations to work from home, is that you can actually do your job from home. So when it comes to the employer's obligation, they do have that obligation to accommodate up to the point of what's called undue hardship, meaning it has to actually be possible for the employer to be able to accommodate you. It has to be possible for you to be able to work from home. And if you're not able to work from home, if, let's say, your job can only be done in person, then unfortunately that accommodation will not be able to be carried out by the employer. It just wouldn't be feasible. But short of that type of situation, if a very small part of your job can't be done remotely, but most of it can be, that would not amount to undue hardship. It really has to be a situation where you really can't do the vast majority of your job remotely. And that's where the employer would have a bit of an exception in terms of accommodating. But for the vast majority of employees that we speak to and employers, there would be that accommodation. The other thing to keep in mind, if you are a parent or somebody that's dealing with childcare obligations following the school closures, is that if the accommodation is not possible, if it would be an undue hardship, if you can't perform your job remotely, you do always have a different type of leave available to you. So if you have no choice, you have to take this time off to care for your child, but you're not going to be able to carry out your job remotely, you can take the Infectious Disease Emergency Leave, at least in Ontario, under the Employment Standards Act, which protects you and protects your job. So if you need to go off work for a certain period because of reasons related to COVID-19, which this obviously would be, then you certainly would be in a situation where you could take that leave. It's unpaid, unfortunately, unless your employer has some sort of other arrangement set up for its employees, but it would generally be an unpaid leave. And then you would be able to go right back to your job. Your job is held for you, it's protected. You cannot be fired because you took this leave. You cannot be demoted. You can't have your hours changed because of it. You go right back to the exact same job with the same terms and conditions as you had before, as soon as you're able to, as soon as hopefully the schools reopen and you no longer have those same childcare obligations. So it's very important to keep all of this in mind as we kind of navigate these new issues or these kind of renewed issues in terms of these school closures, so that as an employee, you do have rights and you do have options. You don't have to, for example, quit your job just because you have to take care of your child. There are options, and it's very important for you as an employee, and especially someone as an employer, to know what each party's rights and obligations are, so that you can work together to make sure that everyone can find their way through this very challenging time as smoothly as possible. So I'm having a bit of a technical difficulty here seeing any of the questions that are being sent in. I'm going to keep trying on my end to try and see these questions coming in so that I can get to that. But for now, I see there's a question Francis is asking on Facebook. When does the infectious disease leave end implemented by the Ministry of Labor? So to answer your question, Francis, as of today, the infectious disease emergency leave, which as many of you might know is a type of leave that is implemented now by the provincial government. It was put in place last year. It's retroactive to March 1st of 2020, and it was first implemented up until about September of last year. So that's when it was supposed to expire. And in terms of the actual infectious disease emergency leave, it encompasses anybody that would have been rightfully and lawfully put on a temporary layoff, or someone that was put on a temporary layoff that accepted it during that period. Or, as I mentioned before, if somebody had to take some time off work because of COVID-related reasons, the government has implemented this infectious disease emergency leave. It was supposed to go until September. I think the government was hopeful that things would be better by then. Then they extended it to January, I think 2nd, or the first couple of days of January of 2021 of this year. And then, unfortunately, they had to extend it again all the way to July 3rd of this year, July 4th. So to answer your question, Francis, as of today, that is the date upon which the infectious disease emergency leave is supposed to finish. So, July 3rd and July 4th it's the weekend. So essentially, if you're not called back to work by July 2nd, which is a Friday, which I expect to be a holiday, so we go to July 5th, if you're not called back by that Monday, July 5th, then you would be able to potentially claim constructive dismissal, or your layoff might become a deemed termination, in which case you can then pursue severance pay. But to answer your question, that's when it's slated to finish. subject to any further extensions that the provincial government might implement. So I see I have another question here from Nita, who sent a message to our firm with her question. Nita says, my employer issued me a termination of employment and gave me working notice. He has since told me he doesn't want me to leave and has revoked my termination. Can I still consider, and then the question, unfortunately, I have here is cut off. But I would assume that the rest of the question was, can I still consider this to be a termination? So absolutely, Nita. An employer cannot revoke a termination without the employee's consent. So if your employer terminates you and they decide after the fact that they made a mistake, or they don't want to terminate your employment, or they want to try to take that back or renege on the termination, they can do it if the employee agrees. So Nita, if that's your situation, if you agree to continue your employment and have your termination not be enforceable and not take place, you certainly have the option of doing that, but you're not obliged, you're not forced. So once an employer terminates employment, they're stuck with it. You're then owed your termination entitlements, just like you would if they hadn't tried to renege or withdraw that termination. And so that's a personal choice, Nita, for you to make. If you do want to continue to work for this company, then you can certainly continue and accept that they are trying to reverse it. But again, you don't have to. And if you want to treat it like a termination, because that's actually what happened, then so be it. And you're owed the same amount of notice or pay in lieu of notice, severance pay, that you would otherwise be owed. So you'll have to think about what you want to do here. It's pretty rare that we see this happen, but it does happen sometimes where an employer does try to go back on it. And my advice usually would be, there's a reason for why this happened in the first place. And most of the time you should take it as, a termination and continue forward in terms of pursuing your entitlements. And if you need any help with that at all, Nita, please do get in touch with us. Okay, so I have another question from Ronald on Facebook, who says, I have been classed as an inactive employee, off due to illness or injury, but I have only been offered one other position in 4 years, which I declined for medical reasons. Okay, so Ronald, the first thing that I would need to know is whether you've gone off on a medical leave of your own volition. So it sounds like you took a medical leave. And in terms of returning to work, it's not clear on whether you were cleared to return to work and then the employer wouldn't allow you to return, or whether while you were on sick leave, whether when you were on sick leave, the employer offered you other positions to come back to. So there's a bit of information missing here that I would need in order to give you a bit more comprehensive advice. But what I can say in general, Ronald, is that while you are on medical leave, you're on a protective leave, you don't have to work, you get the chance to go right back to the same job as soon as you're cleared by your doctor to return to work. When you are cleared to return to work, your employer has to put you back into the same position or the most similar position if your previous position no longer exists when you go back. So if you are being offered to return to work, if you are cleared to return to work by your doctor, and your employer is offering you other positions that are not the same, that are not comparable, and that's why you're refusing them, then certainly you're in a situation where you may be able to pursue a constructive dismissal claim, because once you're cleared to return to work, your employer has to bring you right back to work. They can't decide to, wait a long amount of time after that and take you back when it works best for them. They have to bring you back right away. And sometimes that means they need a couple of weeks to get their ducks in a row, so to speak, and make sure they have that job lined up for you and make sure anything that's, required for accommodating you is in place. But beyond a couple of weeks, I'd say that's kind of a reasonable amount of time where the employer has some time to get everything ready for you to return. Beyond that time, they should have you being returned to work right away. So if that's not happening, definitely get back in touch with us. Other than that, Ronald, if that's not your situation, feel free to contact us offline or send in some more details about your situation so that I can give you a bit more comprehensive and a bit more detailed advice to address your specific situation. Excuse me, I'm just going to get to the next question here. So Rupert on Facebook says, I have been laid off since April 2020 because of the COVID-19 and have not been recalled to date. I'm 61 years old, and Rupert is asking, what are my options in terms of severance, etc.? So Rupert, if you were laid off in April of 2020, there's a couple conditions that might apply to your situation. If you accepted that layoff, meaning you've agreed to it in writing, you've signed something that says you're agreeing to it, or there's any sort of documentation or emails or anything in writing that says you agree to it, then unfortunately what that means is then you have to wait until July 5th, as I mentioned before, of this year in order to see if the company recalls you. And if they don't recall you by that time, then it can become a deemed termination, depending on your situation, and then you could pursue severance pay at that time. Now, in terms of a situation where you haven't accepted that layoff, if this is your first layoff in your whole time working for the company, and you haven't signed anything previously, like an employment contract or another type of document where you are agreeing that they have the right to put you on a temporary layoff, if neither of those two conditions are satisfied or exist here, then what that means is that the company is not actually allowed to lay you off, and that your layoff would actually be illegal and would amount to a termination of your employment because they've stopped paying you. So with respect to how the law works on this topic, if you've never signed anything that says they can lay you off, if you've never been laid off before, and if you haven't accepted and expressly accepted this layoff, then the company has stopped paying you. You're not working, of course, but that's not your choice. And then it would become what we call a constructive dismissal, because the company has significantly changed a fundamental term of your employment, meaning they have changed your compensation and it has been changed significantly because it's now down to zero. So when that happens, you can actually treat that as a constructive dismissal, as a termination of your employment, and you can pursue your termination entitlements, in other words, severance pay. So for you specifically, Rupert, if this is your situation, if you haven't accepted it, if they're not allowed to lay you off for the reasons I mentioned, certainly you can treat it as a constructive dismissal, and you can pursue a severance package based on that information. And given the information you've provided, I mean, I would need a little bit more information from you in terms of, the length of service, the position, the age, but given just the limited information you provided, you would be looking at a pretty significant severance package just because of your age, depending on your length of service as well. So certainly you can get in touch with us if that's something that you're interested in doing. For everyone else watching, if you're in this type of situation, it's really important to act as quickly as possible because the more time that goes on from the time you are laid off until you assert the constructive dismissal claim, the more likely the employer is going to try to argue that you accepted it, okay? And that just because you didn't expressly accept it, the fact that you haven't expressly rejected it or asserted constructive dismissal for a little bit of time means that you've accepted it. So it's really important to act quickly and get in touch with us if as soon as you're laid off so that we can assist you in pursuing your termination entitlements. So we have another question from YouTube, and this is, and I'm sorry if I'm butchering your name, Yasas is saying, I was a Canada Post on-call letter carrier, but I could not accept shifts offered to me due to taking care of my children as they are on online classes. Thus, I lost my job, but I want it back. And Yasas is asking for advice. So the first thing, I note that you work for Canada Post. If you're unionized, which a lot of Canada Post employees are, and most Canada Post letter carriers are unionized. So if you are unionized, Yasas, unfortunately, you'll have to go through your union on this one. I won't be able to assist you. No employment lawyer will be able to assist you other than giving you some advice. That's the best we can do here. You can't sue Canada Post in court. You would have to go through your union. So if you are unionized, which I suspect you are, you should be contacting your union rep and speaking to them about the situation, seeing if they will be willing to file a grievance on your behalf. and have you potentially reinstated. Because you are, if you are unionized, you would be governed by your collective agreement. And so the collective agreement would outline what happens in this type of situation where you've lost your job for the reasons you mentioned related to childcare obligations. So there likely would be a right to reinstatement. There likely would be, severance packages outlined. So that's a situation if you are governed by collective agreement and you're unionized, don't waste any more time. Talk to your union rep right away and get the ball rolling on this, because that's the entity that can actually assist you. If you're not unionized, yes, and for anyone who might be in this situation where you're not unionized and you have childcare obligations, as I mentioned a bit earlier during this Q&A session, given the recent closure of lots of schools, this is an issue that's coming up very often, and it's a very hot topic in employment law right now. And so, as I mentioned before, if your children are home from school, in remote learning, and you have exhausted all other options for childcare, as I mentioned before, you've spoken to neighbors, family members, friends. You've tried to put them in the care of others. You've exhausted all other options possible, but you simply cannot find another option. Then there is an ability to have your employer, or an obligation to have your employer, accommodate your request to work from home. The challenge with you specifically, SS, is that you're a letter carrier. So unfortunately, that's not a job that you can do from home. And as I was mentioning before, for non-unionized employees specifically, the employer has a duty to accommodate up to the point of undue hardship. So if you're physically incapable of doing your job from home because your job requires you to be out and about or at a specific workplace, then that's a situation where the employer unfortunately can't really accommodate you, and you would be able to take the Infectious Disease Emergency Leave in Ontario provincially. And federally, there's a very similar leave that you could take, and you would be protected on that leave. So you would be able to take an unpaid leave. In other words, your job is safe in order to care for your children. And there are various government benefits that might be available depending on your exact set of circumstances. But if you are, one of those people where you can't do your job remotely, it's just not possible, that's the solution. But it certainly is not you having to resign from your job or you being terminated because you have childcare obligations. So neither of those things should be happening. So for you specifically, SS, if you are unionized, go to your union right away. Excuse me, if you are not unionized for some reason as a letter carrier for Canada Post, certainly get back in touch with us and we can provide you with some additional assistance depending on what your exact set of circumstances are. So I'll get to the next question here. Evelyn on Facebook says she's on a temporary COVID layoff since last April. The company is still providing health benefits till July. So I assume that is July of this year. They are not able to provide me with a return date at this time. Is there anything I can do to bring up the severance? And then it goes on, question, I may need a reference. And then the rest of the question, unfortunately for me, is cut off. Oh, there we go. May need a reference from them for a future position. Perfect. So in terms of your situation, it's exactly what I was just explaining a few moments ago. If you are in the category of people where you've never been laid off before, you haven't accepted this layoff in writing, you haven't signed anything, you haven't agreed to it, and you've never had an employment contract previously or something else you've signed that says you agree in advance that the employer is allowed to lay you off, if none of those conditions are met here, then again, you can treat the layoff as a constructive dismissal, and you can pursue your severance entitlements, your termination entitlements. In terms of how to go about doing that, because this is a very kind of sensitive, complex legal issue, you certainly don't want to be doing that on your own, because the likely response you're going to get from your employer is that it's not a constructive dismissal because you're on infectious disease emergency leave. Now, that might be true under the Employment Standards Act, but in the other legal system, which is called common law, which is actually the system governed by the courts and the decisions and the judgments that come out of the courts, it's not considered infectious disease emergency leave. Infectious disease emergency leave only applies under the Employment Standards Act. It does not apply to common law. So you're going to want to get in touch with an employment lawyer. You certainly can get in touch with myself or any of my other colleagues, again, by going to employmentlawyer.ca, getting in touch with us. You can also email us at help@employmentlawyer.ca and get in touch with us so that we can assist you in pursuing that. There may be some other circumstances that might assist in pursuing your matter, that might change some of the kind of general advice I've just given you specifically. But in general, that's the way the law works. So if you are on a layoff, you don't have to accept it. You can consider it to be a constructive dismissal as long as those conditions I've gone through are not present, are not met, and you can pursue a severance package. So certainly you can get in touch with us and we can assist you in pursuing that. And we've certainly, throughout the last year or so, assisted many people in that endeavor in terms of not accepting their layoffs and pursuing a severance package and successfully securing severance packages for people that are in your exact situation. So definitely get in touch with us right away and we can help you with that. I'll get to the next question here. So Ariel from Facebook is asking, after receive severance pay from the company, after finish the severance pay money and still no job, I am still allowed to go on EI. Okay, so Ariel's question is basically, I was let go, I received the severance package, it bridged me from a certain time, my date of termination, up until now, but I'm still out of work now and I've run out of severance pay. Am I entitled to receive EI benefits? And the answer is yes. So if you are in a situation where you are still out of work, unfortunately, your severance package did not or was not enough to bridge you to new employment, which unfortunately a lot of people are in this situation right now, where maybe aside from the pandemic, that severance package might have been enough to get you from your last job to your next job, but it's a little bit more difficult for everyone these days to find another job. So if you are in a situation like that where you've run out of the severance pay, you haven't found another job yet, absolutely you should be applying for EI benefits. And not only that, but once you have a final severance package, in other words, once you have your severance package that you've accepted, that is final, and you should be getting legal advice on this for sure before signing off on anything. But once it's finalized and you know exactly how much severance pay you're getting, you don't actually have to wait for that severance pay to run out. You can apply for EI right away through Service Canada. You won't necessarily be eligible to receive it right away, but at least you'll start your claim, and EI or Service Canada will know how much severance pay you're receiving so that your payments for EI can start right away as soon as they're supposed to. Because otherwise, if you wait, there might be a bit of delay there where you've run out of severance pay, but your EI benefits haven't kicked in yet, and then you have no income coming in at all. So I definitely recommend for anyone out there that's in a situation like this, as soon as your settlement is, or your severance package, whatever the case might be, is finalized, make your claim to EI and start the process so that there is no delay in the future if you haven't found another job by the time you are, run out of severance pay or eligible for EI benefits at that point. So we'll get to the next question here. Tammy from Facebook says she was employed for 14.5 years. She was let go without cause. How much severance can I expect? Well, first of all, Tammy, I'm very sorry to hear that. It's never an easy thing to go through, especially right now. It's a little bit stressful because of the pandemic. With 14.5 years of service, certainly your entitlements will be significant. I would need to know the other circumstances that you're in, so your age and your position, among a couple other things, in order to determine more accurately what your entitlements might be. But usually for someone in, with your length of service, it will vary depending on age for sure. If you're 30 versus 65, there will be a significant difference there. But just based on the length of service alone, you could be looking at severance entitlements in the range of a year or so. So I would really recommend that, Tammy, you get in touch with us and do provide us with that additional information so that we can give you a more accurate assessment of what your entitlements should be, because the odds are that whatever you've been offered is not enough. In our experience, more often than not, and I'd say 9 times out of 10, if not 10 times out of 10, the employer is not offering what they should be. They're trying to offer as little as possible and hoping that you might not know what your rights are, you might not reach out to a lawyer, or find out what your entitlements should be, and that you just accept what they're offering you because maybe they give you a deadline of a week to make a decision and they try to put pressure on you to accept it. And a lot of people think if I don't take it right away, I'm going to lose it. That's not the case. So if you've been offered a severance package, Tammy, and anyone else in this situation, you have to have it reviewed by an employment lawyer before you make any decisions, before you sign anything. You can use our free severance calculator that we offer as well, or you can, in conjunction, call us or go to employmentlawyer.ca, get in touch with us, and we can provide you with that information as well and give you a more specific estimate of what your entitlements might be. But never, ever, ever sign something without first getting it reviewed by an employment lawyer, because the odds are you're going to accept something that's way lower than you should. All right, I'm going to get to another question here from Facebook. So I don't think this is the person's name, but Tigers, I think that's how you would pronounce it, is saying if your employer, or is asking rather, if your employer fires you after making a Canadian Human Rights Commission complaint, can you go after them for damages? That's a great question. The short answer is yes. So if you are in a situation where you are trying to assert your rights, if you are filing a human rights complaint, and that's with respect to the federal level, the Canadian Human Rights Commission, or provincially at the Ontario Human Rights Tribunal or the BC Tribunal or in Alberta, whatever the case might be, if it's human rights, if it's an employment standard, if you are trying to enforce your rights as an employee because your employer is not treating you legally or fairly, and you're trying to assert those rights, your employer cannot treat you differently or negatively because of it. And that is called reprisal. So if your employer is engaging in what we call an act of reprisal against you, meaning they've disciplined you, they're not treating you nicely, or they're not treating you like they were before you asserted your rights by either filing a complaint internally, or maybe it will be with the tribunal, whatever the case might be, leading up to the most extreme act of reprisal, which would be a termination, that's illegal. You cannot encounter any negative repercussions for asserting your rights within the workplace. And so absolutely, you do have a claim for additional damages for reprisal under specifically the human rights legislation, the Canadian Human Rights Act, for your specific scenario, Tigers. But in general, all of the applicable legislation that governs all of these types of issues have a section about reprisal, and they all prohibit reprisal. So whether you're in a human rights tribunal arena, or you're in employment standards, or whatever the case might be, if you file a workplace harassment complaint, if there's a health and safety issue, whatever the case might be, if you are trying to assert your rights, you cannot be reprised against for it. And employers, depending on what forum you're in, if it's employment standards or human rights, they can face significant penalties and fines from the Ministry of Labor from that. And in the context of a human rights complaint specifically, you can actually add an additional head of damages now and an additional allegation to your complaint to the Canadian Human Rights Commission. So for that specifically, you can actually amend your complaint and now add that after you filed that complaint, you were fired, you were terminated, and that constitutes an act of reprisal, and that you're entitled to additional damages for that. So certainly that's what I would recommend here, because that is completely unlawful. So I do know we have some additional questions here. So I'm going to just get to another one question. I know we have a few here. I'll answer one more question. And then if we did not get to your question, please reach out to us offline. Go to employmentlawyer.ca, get in touch with us. You can email us, you can call us, you can contact me directly or any of our other lawyers, and we'd be happy to answer your questions so that you get the answers and the advice that you're looking for. So I'll just get to the last question for today. Rory on YouTube is asking, can an employer lay you off and hire a contractor to do your job while you are getting EI? Could this be fraud? The union has done nothing for a year. Is this against fair representation? So a bit of a loaded question here, Rory. I see you're unionized. So as I mentioned to someone else who asked a question earlier, if you're unionized, you have to go through your union. So if you say the union has done nothing, I'm not sure what steps have been taken to get in touch with the union. I'm not sure what the process has been, if any, but you have to go through your union. So, you have to email your union, call your union rep, get in touch with them, and they are the ones that would have to assist you with this type of issue. What I will say in general, and especially for those watching who might not be unionized, is in terms of a termination, an employer can certainly terminate your employment and then replace you with someone else, as long as they're providing you with your proper termination entitlements. In terms of the situation that Rory is talking about, I'm not quite sure what the rights would be in the collective agreement that would govern your relationship, because the collective agreement itself would be what addresses the right to lay you off, how long that can go on for, what the rights of replacement are. All of those related issues would be addressed in your collective agreement. So that's something that you would have to address through your union based on what's in the collective agreement. But if you're non-unionized, you don't have a collective agreement, you can't just be replaced if you don't want to be. So in other words, you can be terminated without cause and provided with your termination entitlements, and then an employer can replace you. That's their prerogative. But if you're being put on a layoff, but then having someone else replacing you and doing your job for you while you're on a layoff, that doesn't fly, and you don't have to accept that. So if you are in a situation like that, once again, you don't have to accept a layoff to begin with if it's unlawful. And secondly, and more importantly, if you're on a layoff because of an alleged lack of work and the employer has actually replaced you or has someone else doing your job or has hired other employees while you're on a layoff, again, that's not going to fly. They can't do that. So if that is your situation, definitely get back in touch with us or get in touch with us and we can assist you with that situation. So we're going to leave it at that for today. I apologize for those of you who we didn't get to your question, but certainly get in touch with us offline and we can answer your questions that way. Otherwise, I will be signing off for today. I wish everyone a wonderful weekend, and I will see everyone in the next question and answer session. Bye-bye.